Well, today is Saturday, the day after Robin Long's court-martial hearing. And what happened yesterday was that we had plea and sentencing. In the plea and sentencing hearing, Robin Long pled guilty to a lesser included charge of desertion with intent to remain away permanently, instead of the more serious charge of desertion with intent to shirk hazardous duty. And we went into the plea and sentencing hearing with a pretrial agreement, which was sealed up in an envelope. The judge didn't know what it was, but the pretrial agreement set the maximum punishment allowed to be 15 months in jail, no more than that. So we went into the court hearing with that agreement sealed up. So then the judge, we had to do what's called providence. The judge had to be convinced that Robin actually is guilty of what he's pleading guilty to. This is a unique element of the military system. So that took about an hour to prove that Robin, in fact, did desert. Once we had made that determination, the judge pronounced him guilty, and then we had a recess and came back for the sentencing phase. In the sentencing phase, the prosecution, what they offered for evidence was a 6-minute video interview of Robin that was done when he was in Canada, shortly after he was first arrested by immigration authorities there, before he was deported. And he was released out of jail for a few months and later was arrested again and then finally was deported. In that interview, Robin spoke about his life in Canada, spoke about his opposition to the war, and was just very much speaking about his life and his belief in peace. There was nothing offensive at all, but for the military, the idea of thinking for yourself, the idea of daring to question, as a threat. And so for them, they saw this as horribly damning, aggravating evidence. And in sentencing, the prosecution offers aggravating evidence. In other words, evidence that says, yes, you're guilty, and we should throw the book at you because you did all these other things. Now, on the other hand, when the defense came to the stand, our side, we offer mitigating evidence. And mitigating evidence says that even though you are guilty, you should be punished less because you had a really good reason why you did what you did. So, for our side, Robin first came to the stand, and he gave what was called an unsworn statement, also a unique feature of the military system that allows a defendant to speak and give their own statement on the record, but in an unsworn fashion. And by doing so, it keeps the prosecution able to cross-examine you. So it's a tactical thing. So Robin spoke, and he wrote himself. It was very moving. He talked about his life growing up. He expressed apology to the military, actually, for wasting their money and resources on him. And that he expressed that a contrition for the fact that of how he did what he did. He doesn't regret morally not going to Iraq. He couldn't go to Iraq. It had been immoral to go to Iraq. And he said that. But he also said he regretted the way he went about it. And he apologized to the Army for that. He says that the method he used was illegal. And he wished he hadn't have gone that route but went another route. So Robin told a story of his growing up years, of why he joined the military. He told about his decision to go to Canada. He told about his life in Canada, about his life with his son, about his love for working in organic agriculture in his hometown community up there of Nelson, British Columbia, and spoke of his longing to be back there. And at the end, he asked for the court to show him mercy and to give him a shortened jail sentence based upon the circumstances of the case. Our next witness was Mathis Chereau, member of the U.S. Army who is out of active duty but is currently in the Individual Ready Reserve, which is an area in the military where that a soldier is back home living their civilian life but can be called back up to active duty. In Mathis's case, and he's actually Sergeant Mathis Chereau, he was called up recently and very publicly he refused to deploy to Iraq. Thus far has not been court-martialed but could be facing a punitive discharge of some kind. In the cross-examination, of course, the prosecution picked at Mathis, accused especially of his decision of what he did. And then we went to retired Colonel Ann Wright, a career member of the military, served a total of 29 years in the military and active in reserves, and later served as a diplomat. I think she served about 16 years all over the world. One of her most exciting assignments being she helped to reopen the U.S. Embassy in Afghanistan after the U.S. invasion of Afghanistan. But she also told about her decision of conscience to resign her position in the State Department because of her opposition to the war in Iraq and the illegal and immoral way that the war was entered into, and what that cost her, and the personal and professional consequences of her actions. We then, from there in our testimony, she talked about comparisons of Robin's actions and how that Robin's actions as a person of conscience are important and are something the military should not be punishing. In cross-examination, the prosecution saw fit to discuss her extensive arrest record of her time after her leaving the State Department, of which she'd been arrested about 10 times for acts of civil disobedience. On redirect, I questioned her some more and basically made it clear that this is something she's proud of and that she's a very patriotic person. And being arrested because you're speaking out against war is a quite heroic thing, actually, and is really what she did and what Mathis did. Is very much in the same tradition of what Robin Long did and what the great civil disobedience leaders in the past did. Even going back as far to the Founding Fathers of our own country, who dared to write a Declaration of Independence, defying the laws of their land at the time, to say, we will not live under tyranny anymore. Sometimes you have to break the law for the sake of morality, and that's what Anne testified to. Following that, both sides presented their closing arguments. The prosecution said that Robin lacked duty, honor, and integrity. Accused made him out to be the worst person to ever walk the face of the earth, and that he's a shameful person and deserves the maximum punishment allowed by law. In defense, we presented the argument. I said, look, you've heard what the prosecution says about Robin, but that's only one part of the story. Let's talk about the rest of the story. And spent some time reading statements from people in Canada who Robin has lived with, and spoke of the kind of person he is, the kind of father he is. From there, we talked about the issue of the morality itself of civil disobedience and the function that civil disobedience has served throughout history. And finally, in closing, I made the argument that Robin should not get a long sentence based on both the morality of his actions, but also based on the fact that Robin did not miss a full deployment in Iraq, but rather was only filling a 3-month spot of someone that he didn't miss a full deployment, he only missed a 3-month short deployment. And so it doesn't seem fair to give him the full sentence. Following that, the judge went into recess, and then when we came back, she announced that she recommended him get a 30-month sentence. However, the pretrial agreement was 15 months, so that set the cap. So Robin was sentenced to 15 months in prison, a dishonorable discharge, and a reduction in rank to the lowest rank E1 private.